I mean, I had a case in which a board president just outright failed to read these governing documents. I mean, these are documents that this board, they're bound by. I mean, this is a governing document. This is the declaration, the articles of incorporation, the bylaws. But what do? No, they decide to pivot, not listen to them whatsoever, and do things on their own.
I'm Luke Carlson, and for almost 2 decades, my law firm, Carlson Law, has been at the forefront of defending homeowners against overreaching HOAs. We're not just leading the charge, we've created the go-to playbook on how to fight back effectively. Join us as we delve into the world of HOA disputes, sharing insights from our extensive experience and landmark victories. Throughout this podcast, we'll bring you in-depth interviews, demystify complex legal principles, and provide practical tips to safeguard your rights. While the information provided shouldn't be taken as legal advice, our aim is to empower you with the knowledge, strategies, and real-life success stories needed to navigate and overcome the challenges posed by overreaching HOAs. Hi, Luke Carlson of Carlson Law. Welcome back to the show, Bad HOA. I have our producer, Marty. Welcome back.
Thank you for having me. Good afternoon.
Good afternoon. It's always a pleasure. And very special treat, we have one of our Florida partners, Stephen Chack, on the show. Stephen, welcome.
Thank you. Thanks so much for having me, guys. Really appreciate it. Appreciate the opportunity today.
Yeah,
it's always fun to see a new face on the show. I mean, you have to talk to me, for episode 12,
like
dozen episodes.
You're
like,
we like to mix
gosh.
it up.
And to throw a new face on it definitely adds some new seasoning to the stew.
Yeah, we spice this thing up. So, Stephen, welcome. You're one of the partners in Florida. You're holding down the fort in our Florida operation. You're doing amazing work for homeowners. But let's ask you a couple questions, so the audience gets an idea of your background. So let's start with the simple one. Where did you go to school?
Yeah, so I went to undergrad at Penn State, and I'll be honest, through and through, I'm a New Jersey kid at heart. Philadelphia, New Jersey, New York. That's my bread and butter.
Okay.
But then came down here in 2010 for law school at St. Thomas University School of Law, a little bit outside of Miami. Just kind of fell in love with the area. And look, after growing up in Princeton, it's kind of a natural transition, we'll say, down here.
Wait, are you telling me a guy from New Jersey / New York ended up in Florida?
Bizarre.
I've never heard that story before.
Well, let me add to that for you. Not only that, well, my wife and I, we live in Boca Raton with our 2 young kids, and yes, in an HOA, and firsthand, look, it's boots on the ground, so to speak. I'm seeing the pros and cons of being a member in that HOA.
I bet. So I love the topic you chose, by the way. So, we had you pick the topic, and it's very close to our heart because we've discussed this before, but it's how to get rid of your tyrant board member, removal and recall of the tyrant. That is a great topic because if you look, historically, we've looked at all the different personality types that really create a dumpster fire situation in an association. And by far, I think the most, I don't want to say hated, but I mean, the most hated is the tyrant personality. So I think this is a great topic. So let's start with sort of this notion of tyrant. What is the tyrant? How do you identify the tyrant versus, for example, a meddler type, or they're strictly incompetent? There's something that makes the tyrant somewhat unique in terms of all the different personalities we've discussed. How would you articulate that, Stephen?
Other than sadistic.
Yeah, right.
Sometimes even self-serving, one might add. And sometimes you get into there where why are they these board of directors and this board director in particular? Why aren't they on the board, and what's their purpose? But look, we know that all board members, they're not created equal, and some
Right.
are good, and some not so good. But and I want to focus on some of the rights that these owners do have, condo owners and homeowners. When it comes to these bad actor board members, this tyrant, and how to hold them accountable, quite frankly.
Yeah, what's interesting about the tyrant I found is that there is a position, it's volunteer. Boards are by volunteer, but they jump into that position because they want the power. They want the control. They want to have the community bend to their will. And that puts them in a unique space because they can wreak absolute havoc on a community.
Shouldn't that be the litmus test? Didn't George Washington not want to take the presidency, or they wanted to make him the king? And then he's like, absolutely not. I
Well,
don't
they
want
say the
this.
best way, the best leaders are the people who do not want to step in that position.
Yeah.
And I think you've seen this as well, Stephen. Some of the best board members or the well functioning associations, which do exist, are typically people who said, you know what, I can do a better job. I don't necessarily want to do this, but I can bring a lot to the table. And I think that sets up a situation where you have a very well functioning association. But the tyrant type is not like that.
Yeah.
They are looking for power. They're looking for control. And often, as you said, Stephen, it's very self-serving at the end of the day.
Yeah. Yeah. And I mean, quite frankly, sometimes they're not even really, it could be a misinterpretation. But you've had previous podcasts on the governing documents. Sometimes they're not even reading
Right.
these governing documents, quite frankly.
Because they are the rule of law, right?
Yeah.
What they
Yeah.
says goes, or what they say goes.
Yeah.
So let's start with red flags.
Yeah. Let's identify the tyrant.
Like how do you see that? How have you seen that present itself and materialize in your world?
Yeah. I appreciate you bringing that up. I mean, ultimately, it's really the either the misinterpretation or just failing to read those governing documents. So, I mean, I had a case in which a board president just outright failed to read these governing documents. I mean, these are documents that this board they're bound by. I mean, this is a governing document. This is the declaration, the articles of incorporation, the bylaws. But what do? No, they decide to pivot, not listen to them whatsoever, and do things on their own. So, I mean, I've seen that where it's not just the misinterpretation, but it's just failing to read those governing documents. And trust me, it's a concern that we see frequently.
Yeah, and I think that's a good point because and you can almost put a finer point on that too because you have two types, you know, with the incompetent, they fail to read maybe because they simply don't know that that's what they need to read. But almost with the tyrant, it's that intent. They know it exists, they know it's there, but they intentionally ignore, bury their head in the sand, or they don't read or they simply don't care. Would you say that's a fair assessment and sort of how you can sort of identify a tyrant versus the incompetent?
Yeah, somewhat oblivious to in nature, not understanding that what they're doing and then the position that they're really jumping onto, the responsibility, the obligations that are at hand. And
Yeah.
and really, yeah, it's just kind of jumping into that.
We've mentioned this before, but these are homeowners primarily. They might not have any sort of business experience or managerial experience whatsoever. So they get this God complex sometimes when they get into a position of power and don't realize the fiduciary obligation of the role that they just took on and run like mad, thinking that they're above the rules and can do whatever they want, which is completely false. I think that 90% of these cases that I've seen or just observed are just the people that get into power. They don't know how to manage people. They've never had a position of power and they want to force their will.
Yeah. And they simply don't care. I mean, you reference fiduciary and Stephen, I'm sure you've seen how powerful fiduciary duties are. And when there's a breach of that fiduciary, how empowered the homeowner is to take action. But the tyrant doesn't recognize it. That tyrant may acknowledge, yeah, I owe a fiduciary, but I don't care. It's not incumbent upon me. I am now in charge. I'm going to do what I want, and it's my will versus everything else. And everything else becomes secondary, in at least in the eyes of the tyrant.
Stephen, give me a couple red flags of a tyrant. Like, how do we know we're dealing with the tyrant? Like, what are some of the behaviors that you see of a tyrant that's on the board?
Yeah, I'd say besides for that misinterpretation or just failing to read, you got into the abuse of power. You got these conflicts of interest that come up. And, oftentimes you got to ask yourself, is the board member making these decisions primarily to serve their own self interests? Or is this the interests of the association and of its members?
Give me some
And
specific examples. Like, are we talking no one's allowed to put solar on their house, and the tyrant will say yes, or he'll ordain his buddies to, yeah, you can go ahead and put solar on your house, or the flags in the front. Give me some specific examples, some decent examples.
and I'd love to have a whole separate discussion on the solar because it is a hot button topic. But no, quite frankly, I mean, you got to look at, are they sending notice of a violation to you only? Are they, after you really do the due diligence, going after you?
Oh,
And
that's a great point, Steve. That is, I think we should pause on that because I think to identify a tyrant, you often kind of trace it back to, okay, I'm receiving all these notices, I'm being targeted, and that is a, tyrant 101 to
Mm.
flex their will upon an individual to the exclusion of everyone else. I mean, I think that's a very, very specific way that a tyrant can be identified.
And that could be like, there's no political flags. You're not supposed to have political flags, but yet every single person has one, but only this particular neighbor is receiving notices of violation.
Correct.
So,
And it's being derived from the tyrant because the tyrant shows up and he or she says, hey, I don't like this one. Let's send notices to this particular homeowner or group of homeowners.
I don't like that particular flag.
Yeah, exactly. No, I think that's a great distinction, Stephen. So with the red flags, you're a homeowner. I'm seeing this. I'm in a Florida community. I have a beautiful golf cart. I have a beautiful situation. I have this tyrant on the board. I know they're a tyrant. I've seen the red flags. What can the homeowner do? Because really, the show Bad HOA, the podcast, is about empowering the homeowner. And oftentimes, what we see is they feel very helpless. They feel like they have no power. They say, "Well, tyrant's in charge. I think I just have to take it." But I know you have a very different view of that and different perspective, Stephen.
And let me add to that too. So much of this show has been the distinction of, hey, you have a lot of power, and here's the tools that you can use to enforce that power that you have. But then drawing the line, okay, at what point do I need to bring in outside counsel? When do I need to bring on a lawyer? Where is that threshold where I finally need to call somebody?
Yeah, so maybe Stephen, this could be a bifurcation, right? You're the homeowner, you want to go up against a bad tyrant, or you want to get them removed, or just by force.
You want to do something to stop the tyrannical behavior.
Correct.
Yeah.
What does the homeowner do first before engaging a lawyer? Sort of, what is that procedure, or what do you recommend initially?
No, that's great. What I like to call it I call it the 50-10 rule almost. There are different mechanisms, and look, I don't want to get too far into the issues of the statute, but there are distinctions when it comes to a condo association and a homeowners association. But if under the condominium statute, first of all, I say the number 10 because 10% generally of owners can sign a petition, sign a document, and what that document is going to allow is for those owners to have a special meeting called.
Mm.
And if you can get to that threshold, I mean, we're talking 10%, you go to that meeting, you voice your opinion, you bring your concerns to other owners that should also care about these issues. And ultimately, that's how you bring this up, and that's the 10%. So I value that number, and yes, I mind you, there is another threshold, and that 50% number, you don't even need to have that meeting. So a lot of times you do get that tyrant board member, and you get the position that these owners, they've had enough. And yes, I want to caution, and there are certain procedural mechanisms and hoops to go through, but there are definitely mechanisms in place to remove a board member if the majority wants that to happen in place.
Well, let's run that through. Let's run the two scenarios.
Yeah.
One, I go grassroots. I go knocking on the doors, and typically with the tyrant, you're not the only person
Yeah.
who has disgust or disdain. You get the 10%, you get the special meeting. What happens at that meeting?
Can we back that up for just one second? Because I was unclear on how you call that special meeting. Because my first inclination is that if they have a tyrannical board member and you declare a special meeting, would they say, well, it's not an official meeting? It has to go through the board. Like, what are the mechanisms in place in order to have an official meeting on the books?
Okay, so going a little bit slower. We go grassroots. We get the petition. I get 10% of the 10% of the community signing on to it. Say yes, we need to do something.
Now what?
What happens there, Stephen?
Right. Again, we're talking about a condominium association. But at that point, you're going to want to now default and look at your governing documents, because what happens then at this point is that meeting does need to be called, and there are going to be violations of the governing documents and of Florida statute if that eventual meeting is not called.
Okay.
And that's where there are procedural mechanisms in place that it is important at that juncture to really make sure, and these board of directors have to ensure that the owners that are speaking up pursuant to that 10% have the opportunity to be heard.
Okay,
And
so
then
let's
once
run.
that,
Oh,
yeah,
sorry. Keep going, Stephen. Keep going.
no, and once that meeting is called, and I have every faith in the system, to be honest with you, that that meeting will be properly noticed, and those members will have the opportunity. And that's where you get out the support, you rally the troops, and you really spread the message that this is your property, and you've got to make sure that these board members are held accountable.
So
And so that's a little bit more about that meeting. But yeah, yes, please.
yeah, at that meeting, you have the troops. You've stormed the castle. You're there. There's pitchforks, right? You know, people are just going nuts on this tyrant. What is the outcome you're looking for? Are you looking to put community pressure on the tyrant where the tyrant raises the white flag? Or how do these things materialize? What is the objective, I guess, of that meeting? Or are we simply looking to curb behavior?
Yeah, it can come in a number of ways. Now, the goal is to have that board member step down from office, quite frankly.
Okay.
If that's the objective and you're rallying the troops, so to speak, and the board member doesn't want to put up a fight and they understand that the community is putting their voice, making their voice heard, very well, fine. But quite frankly, sometimes you get board members that want to argue that want to see it in their own right. And that's where you've got to make sure that they are held in check.
Okay. And you also mentioned a 50% threshold. What does that look like? So, you know,
Yeah.
we kind of ran through the 10% vertical. What happens at 50%?
Yeah. So look, the 50% is it's ultimately it's the majority. So you want to get 50% plus a few, I like to say, to be able to sign a written recall agreement or a ballot.
Okay.
So, for instance, it might be difficult for you to get those owners to come to that meeting while you're able to get the 10%. But maybe in your community, and maybe you're a community of 15, maybe you're a community of 50, or maybe a community of 100 or more, but if you're able to get out that vote, get out that community awareness, they can really just sign a one-page ballot, a written recall agreement. Now, mind you, there are some pitfalls of that written recall agreement, and we'll talk about the voting certificate in just a few minutes. But that would be one of the strongest mechanisms because once the board is properly served and your governing documents again are going to provide the specific individual, once that board is properly served, then effectively that board of director would be removed and recalled from that position.
That's tremendously
So it's
powerful.
very strong. Yeah, it's a powerful tool to use and implement.
So you put a little asterisk on that. What is this certificate? What is this?
So, one of the many concerns that could come up is a voting certificate. So, governing documents may require that, for instance, if a property is owned by a corporation
Mm,
or in the name of a trust, that there needs to be one individual that has voting authority for that property.
Hmm.
Oftentimes, a very simple process in the realm of providing to the secretary of the association we've seen in the past, just notifying them that authorizing that certificate has been filed. But one of the many processes, and I'll be honest with you, there are others.
okay. So that was the flow for a condo association or a COA. Now let's
Right.
flip it over to the HOA or homeowner association. What does that look like?
Yeah. So you also have, again, the 50-10 rule, mind you, but it's a slight variation there. And so, in this sense, you are going to further want to default to your governing documents. And so, your declaration, your articles of incorporation, and your bylaws may say otherwise. But I mind you, as long as it does require that, you're going to have a similar threshold of the 10% of unit owners and be able to then seek this special meeting for the purpose to recall a director. Now, it's a little bit different, as I'm sure you can imagine, that the language of the statute than the condominium statute. Here, it is also the opportunity for these owners to get out that vote.
Mm,
Now, if the association winds up taking certain positions regarding that 10% and the appropriate amount, oftentimes what you do with the homeowners association is you would proceed directly with that 50% and that majority. But
um,
often you want to default to your governing documents.
all right. Now I want to switch gears a little bit. So I think you have two camps here. One camp that says, yes, I absolutely can get the 10% or the 50%. I know a lot of people are very angry. But let's go to a homeowner who has a tyrant. That tyrant is really just coming down on them. And maybe this tyrant has buddies or cronies. Okay.
Mm.
And this methodology probably is not going to work for a variety of reasons. One, they don't think that they can get the votes. It's too much of an ordeal. What does the homeowner do then? I mean, I think, is that where you're starting to look at that advocate, bringing in a lawyer? How would you assess that? What could that homeowner do? Because a lot of times, again, the tyrant often selectively enforces against maybe one or two or a handful of people, the people they don't like.
Yep.
And if you go to another neighbor, they say, I love Susie. She's wonderful, but she's a tyrant, but she's not a tyrant to me. You see what I'm saying?
She could be a little over the top, but I've got no problem. I don't want to
Correct.
get involved. I just want peace.
Correct. And they don't necessarily want to put their name on it. They don't want to create this whole thing. But,
Yep.
but in the meantime, your life is a nightmare. Every day, you're fearful of opening up your mailbox because you don't know what new notice or violation you're going to get. So what does that homeowner do?
Yeah, I get that. We get that call too many times. And to be honest, that's where I do like to step in. And you've got to implement the steps that you can under the statute with a lot of these pre-litigation rights that homeowners do have and condo owners do have. So the step that you might want to take is even diving into the records and
Okay.
very much finding out how they're treating you differently.
And that's a good point. And we've touched upon it before. And this is a right of a homeowner in Florida to seek documentation, correct?
You've got it. We have this transparency as far as record keeping and official records. And that's where this homeowner or condo owner would be able to do that due diligence and, quite frankly, flip the script on
Right.
that board member tyrant who's coming in here, sending those violations and thinking that the messaging that it's just they're the bad guy, but no, it's not that case. And how do you do it oftentimes? And hate to be the lawyer in me, but it's the documents speak for themselves. So you perform an official records inspection.
Understood. So walking this through, the homeowner does this, or their attorney does it, right? The advocate comes in, puts a ton
Or
of pressure on the board. The board capitulates and says, "Here's the records." And now you see clear violations. You say this is a pattern and practice of abuse. This is a tyrannical board member, and I see clear targeting. What does the lawyer do, or what does the homeowner do at that point? Because now you have some ammunition,
You
right?
bet. You bet. And, you know, one of the strongest mechanisms for a homeowner and a condo owner is the pre-suit process to demand mediation, quite frankly.
Okay,
It is
let's
a
let's talk about that for a second because there's a difference between the mediation or the ADR, alternative dispute resolution process, and filing formal litigation or even arbitration. So could you walk us through what does ADR actually look like? What does it entail? How is it triggered in the first place?
Yeah, no, great question. And ultimately, one of the positions that you may want to take after doing this records inspection, and you might wind up finding that the association is breaching their very own governing documents. If that's the case and they're in breach of contract, Florida law does require a homeowner and condo owner to go through this pre-suit mediation process prior to filing a lawsuit. So it's not just a strategic avenue, but it is required by Florida law.
So it's procedurally required before jumping into full-blown litigation, which actually can be a benefit because, litigation obviously very expensive. I mean, it's expensive here in California. It's
Yeah.
expensive in Florida. So this is a avenue where a homeowner whose rights have been violated can enforce their rights in a way that doesn't require full-blown litigation, but it is a demand for ADR on the association and sort of forcing them into a mediation context to get this thing resolved.
Yeah, you got it. Bringing them to the mediation table. That's what I always say. I mean, if you get them in front, you get them thinking about it on that day. Yeah, it might not be your day in court, but it's your day at mediation. And everyone at that point is focusing on that dispute. And look, sometimes there is the issue that the tyrant becomes the meddler. And
Right.
look, I'd love to explore that. And maybe it's just maybe that's the mediation and the mediation table, that opportunity to bridge and bring everyone closer. Because I'll be honest, that's one of the reasons why I got into this area of law. I like to help homeowners, but the goal is bringing everyone back together
Well,
because we're all neighbors. We are.
yeah, we use this statement a lot, but sometimes in order to procure peace, you have to go full blown war. right? I
Yeah.
mean, you have to enforce your rights to an extent, and you have to show that these rights matter.
Yeah.
Because if they don't, then the abuses continue, the violations continue because you have a board or a tyrant that goes unchecked. And at least this is true in California, and maybe you can speak to it in Florida. When the ADR goes out, often what happens is the lawyer for the association gets involved. And that can be very meaningful because if it's just the homeowner going up against a bad HOA or a bad tyrant, it becomes this sort of pit, right? It doesn't go anywhere. It's this, sort of this dead end for them. But the lawyer coming in, the lawyer sending the ADR demand, it goes to the lawyer, it goes to counsel. And it's quite possible, and I've seen this time and time again in California, that lawyer had no idea of the violations. They had no idea that a tyrant was sitting on the board. And this sort of, shines a huge spotlight on the situation. Do you see that in Florida as well? Once the lawyer gets involved, sort of the DNA and the dialogue changes quite quickly.
Oh, yeah. Quite frankly, I think what it comes down to is liability exposure.
Right.
And I think sometimes it takes until the attorney for the association has a conversation and discusses what those actions and the consequences of those potential actions are. And then, yeah, the ship is righted. But, look, you never know how that approach can take.
Yeah.
Um, I'll be honest, that's what I do every time. I like to resolve a dispute. I like to get on the horn with counsel from the association. But very much so. I mean, I'll be honest, it does. It takes two to tango.
Right.
And if you do get opposing counsel and you do get some communications, that's where it is. I call it. It's about liability exposure, and the hope is that they're aware of it.
Right. Yeah, we see that a lot in California. Now, I want to touch upon this. I'm seeing this as a tremendous win for one of our clients in Florida, but there was a successful removal of three members of the board. Can you talk to that? I mean, that's a tremendous victory. I mean, to get one, I think is wonderful, but to get all three removed, how did that come about? I know it was in the context of a condo, but could you shed some light on that story?
Yeah. Look, I mean, I tell you, there are steps throughout the process, and sometimes it might seem like it's a hill that you can't climb, that mountain, but it's not. In this circumstance, all three board members were removed from office. It was the decision of these owners, and quite frankly, that's what it comes down to. If the majority of those owners, and it does happen, and they understand and they see these bad actors, in this case, that's how it really did move forward. I like to bring this up because the voting certificate was very much important in this case. And there are also other considerations. When I mentioned the written recall ballot and agreement, there are certain areas on this written recall ballot and agreement, for instance, they can't be pre-marked. Now,
Okay.
what is that? So there are instances here, and I was very much glad to get involved in that dispute. And because of our involvement, I believe that we were successful and didn't have a dispute to that recall election, to that recall dispute. We were successful, in the three board members that were removed from office were then replaced with the three board members that the majority of owners desired to. And that's what this
Incredible.
is about.
And so that was done by way of the vote. So you were involved in that process. I would imagine you were crossing T's and dotting I's just to make sure that no one could challenge it, which would be the benefit of maybe hiring an advocate at that point. Even before you go the ADR process, before you ratchet up the aggression, you go the procedural route, but you almost have a quarterback, which is the lawyer navigating that process.
Yes, I mean, the way that it also works, and I believe we work in as a team, quite frankly, there is a representative
Okay.
of these unit owners. And this representative of the unit owners, they need to get oftentimes this type of guidance to make sure you're not going back once, twice, three, four times. Because what? You bet that tyrant board member, they're going to put up a fight.
Right.
So you
Yeah.
want to make sure you do it right the first time. And
Right.
it's important.
I love those stories. It's one where it's such a victory. I mean, you imagine just the relief of the community. You get three of those bad actors removed, and typically what fills the vacuum are the people who didn't necessarily want to leave, but they were
Yeah.
capable. They were able to do so. And I think it also shows to the community how good things can be when the right people are in the right seats. But also the flip side of that coin is how bad it can be if the wrong people are in those seats. And congratulations on removing those bad apples.
I have a question.
Hit us.
Can a tyrant run for re-election when it comes back
Ooh,
around?
I like that. So you kick the tyrant to the curb. Can they come back to haunt the board again? What does that look like? Well, assuming anyone would vote for them.
I think that's the tell. But what if
their campaign is like, I won't do it again?
Yeah, no, it's a great question. And in certain circumstances, that board member very well may be able to. But it does come down to the issues and the what you identify and bring forth. Because let's talk about that. If you're removed from office as a board member and you are able to get back on the ballot, sure. I'm going to be honest with you guys today. I believe in that. Maybe this tyrant is, as I've noted, no longer a tyrant at this point. So respectfully, oftentimes you may be able to, but if these actions are egregious enough, maybe they don't want to take that dare.
Yeah, but
They're
think
not
of it
back in
this
the-
way. You know, you have a community who had a really bad actor, a bad tyrant. It's common knowledge. They get removed, and then the community votes for them and gets them back on the board. You know, to the extent, I mean, you're kind of assuming that risk.
For sure.
So
But,
maybe-
half of it is inaction.
Yeah.
Half of the problem is inaction. Guilty as charged. I lived in an HOA previously. Every vote, I'm like, I never showed up.
Right.
So I was not voting, which thus cast my vote.
Right. Well, that was I love that story, Stephen. So thank you for sharing. And so now we're going to transition to a very fun part of the show, which is Reddit Rapid Fire. I'll do the disclaimer now since we're lawyers, so we always have to disclaim. So, you know, what we're going to do is we're going to present a fact pattern. And almost like a bar exam, in a clinical way, you are going to analyze it and you're going to give your general recommendation, obviously not to the person asking the question, but just generally, how do you analyze it? What are your thoughts? Marty has very spicy fact patterns. He finds it from this area of the web where a lot of angry homeowners like to write about, you know, bad HOAs.
Reddit, man.
Reddit.
It just it's ripe with people ready to complain, and there's a whole subreddit culture on people complaining about their HOAs.
Not
it's
surprised.
really easy. It
makes sense to me.
Very easy to get some stories. So yeah, you could just give us your 2 cents, laugh about it, say that was spicy, and we end there. But I always like getting your guys' take on it. So let's jump into it. Okay. Seeking legal advice on HOA retaliation and rule changes in Florida. Again, not legal advice.
Right.
Not giving it.
Nope.
I recently won an appeal with my HOA, which granted me an approval with variance for my front porch screen after realizing the bylaws for my specific community actually allowed it. However, they are now updating the rules to ban screens for future homeowners. When we bought the house in August of 2023, the sales agent assured us upgrades like porch screens were allowed. Several homes already had them, so we assumed it was fine. We installed our screen in September, but in May, we received a violation notice, even though the HOA guidelines only state that screens should be dark bronze, which ours is. The HOA threatened fines and legal action if we didn't remove. Meanwhile, they also issued a separate violation for small solar garden lights despite no rule prohibiting them. This feels like retaliation for pushing back on the screen issues. I'm relieved my screen was approved, but I'm concerned how this was handled and the sudden rule change moving forward. I need legal guidance on. There you have it.
That one's good. I like that one.
I'm concerned how that was handled as well. But I mean, at this point, I still think that owner should utilize his or her rights under the records inspection statute.
Okay,
Don't-
how
don't-
so? So how
don't
so?
let it
So how would
Yeah.
that look?
Yeah, don't
And
let
what
it
are they
stop.
looking for?
Don't take that answer. Don't stop there. Make a request for all applications and the responses from the association. Determine whether, yeah, maybe you were being treated differently than other owners and those submissions. And I think that is an important way to utilize your rights. I mean, I'll perform a records inspection on my own with my own association, just as a diligent homeowner, on an annual basis. Why not? Got to keep them honest.
That's such a lawyer thing
I
to
love
do.
that. Good for you, Stephen. So, okay. So, yeah, I think that goes to what we were talking about earlier, though, just getting the knowledge, getting the ammunition, doing the deep dive. And, there's one thing with perception. You kind of perceive something is happening, but Florida, based upon what you're saying, these homeowners are really empowered to go further than just speculation. They can do a deep dive, and they have the right to do so through transparency and really forcing the association to turn over the books. I love that. I think that's an incredibly powerful tool. So
yeah, I think that the big takeaway for a lot of this is so many homeowners that I've seen time and time again. It's almost the same thing every time, that the homeowners think they have no power. They don't know what to do. They just don't. They have no clue what to do next. And there's a lot of laws in California and Florida that give the homeowners tremendous amount of power. It's just leveraging that, like.
Right.
To Stephen's point on saying you can request the records and all of a sudden you're empowered, which is a huge tool and a huge win for a homeowner to resolve this in a way without needing a lawyer.
I couldn't agree with you more. Stephen, that was fantastic. I appreciate you joining the show. I know you're very busy. You have a huge caseload. A lot of homeowners are relying upon you. And I appreciate you taking the time because ultimately, listen, we're trying to spread knowledge. We're trying to empower. And I think you did an absolutely beautiful job today doing so. So I want to thank you.
Awesome. Thank you so much, guys. I really appreciate it.
Good. And we look forward to having you back on the show soon, assuming your schedule permits.
Of course. I'd love to. I'd love to talk about some of those topics in a little bit more detail.
All right, Stephen, thank you so much. And thank you guys for watching. Again, if you like the show, subscribe, drop us a like. I think they say that now too.
Yeah, all the kids say it.
Yep. And leave comments. We do look at the comments as well. So thank you. And until next time.